This is the application and appeal in the matter of Castleton and Post Office Limited and another.
Yes, Mr. Hodge.
May it please you, my lords, I appear in this matter on behalf of Mr. Castleton with Mr. Young, counsel, my learned friend Mr. Bailey, King's counsel, and Mr. Predes appears for the first respondent, and my learned friend Mr. Midwinter, and Mr. Wilmot Smith, and Miss Klimowitz appears for the second respondent. This appeal is brought by permission given by Lord Justice Lewison. Of the appellant's grounds, he granted permission on the sixth ground of appeal that challenged the order under paragraph 3, core bundle, page 114, that relieves the respondents of having to plead the phrases and paragraphs of the particulars of a claim identified at Annex 2 to the order at core bundle, page 117. Granting permission, Lord Justice Lewison said this: there is a real prospect of successfully arguing that the court directs the trial of a preliminary issue. It should either provide for all the facts to be found or direct that the trial be on the basis that the facts pleaded by the claimant are true. The hybrid approach by the court in this case may well be wrong. My lords, there is an application to amend the appellant's skeleton argument. I will deal with that in a moment, if I may. If I make some introductory observations.
Before you do that, could I say that we obviously had a good opportunity of reading and considering what we've so far had in writing, and our view at the moment would be that we would prefer to move straight to the argument and then to pick up any arguments in relation to the scope of the
I'm very much obliged,
the pleadings. We also are very much aware of a disagreement as to the scope of the appeal itself arising from the grounds that were refused. As to that, we'd like to invite the parties to deal with the substance of the matter in argument, and that we will then take into account in the same way any disagreement as to what issues truly arise on the appeal. And in relation to the argument itself, I think it would help us if we could have some focus in particular on the footnote to the annex to the order, if the parties have that at 116. Whatever the scope of the pleading, whatever the scope of the appeal, we'd like your submissions, please, in particular on the second sub-numbered part of that footnote, which is the issue of the defendant's knowledge of the viability of claims, and how an assumption in relation to that factual matter fits with a factual inquiry in relation to the other matters then set out. And so that's the substantive issue on which we welcome the parties' submissions.
I'm grateful to my lord for that indication. Can I, as it were, give the court an indication as to the terminus of my submissions, which your lordship has just, in a sense, identified, and it's apparent in the argument identified by, or advanced by Mr. Bailey in response to the amended skeleton argument. Essentially, Mr. Bailey's contention is that the assumption made in favour of, the assumption made against the first respondent, the Post Office, in relation to what it knew about the claims that were available to Mr. Castleton in 2019 is to the benefit and advantage of Mr. Castleton. Our submission is that that is wholly wrong, and in fact the assumption short-circuits the ordinary position and in fact disadvantages him, because the purpose of making the assumption was explicitly to reduce the investigation and disclosure exercise against the first respondent by making the assumption. But as your lordships will know, the knowledge of the first respondent of claims available to Mr. Castleton in 2019 at the time of settlement of the group litigation is only one aspect of the law in relation to sharp practice or unconscionability. There are two other aspects. The first being the knowledge of Mr. Castleton himself. But following on from that, if that is established, i.e. if Mr. Castleton establishes on evidence that he did not know of those claims in 2019, the next and in a sense critical consideration is whether the first respondent knew that he was unaware of those claims. And we say that the assumption made against the first respondent in relation to the first issue, what did the Post Office actually know in 2019, in effect militates to Mr. Castleton's disadvantage in relation to the third issue, because as your lordships will see from the footnote returning to your lordship's indication at page 116, the sub-issues for determination by way of preliminary issue are A, did the claimant know of those claims on the 10th of December 2019? Well, putting that to one side, we say that in most respects is very straightforward. If not, did the first defendant know that the claimant was unaware of those claims? And in relation to that second part, that is small b, the way in which that we submit that on the face of it, the burden in relation to establishing knowledge on the part of the first respondent of Mr. Castleton's ignorance lies with Mr. Castleton. That would be in accord with the ordinary principle that he asserts, and he has to prove. That being the case, we submit that the order making the assumption in relation to the first point, what the Post Office first respondent actually knew, that's explicitly intended to avoid the disclosure exercise and elaborate investigation that the first respondent contended before the court below was necessary but for that assumption being made. But that very assumption, by not requiring the investigation and the disclosure exercise in particular that would otherwise be required, is to Mr. Castleton's disadvantage.
There's another way of looking at this, and I'm obviously conscious of the perspectives of the parties, but speaking for myself, it's not just a question of whether something's to one party's advantage or disadvantage, but as I understand, underlying the point you make, is that an unpopulated assumption, an assumption unpopulated by facts, places the court in difficulty in going on to answer the subsequent two questions, and particularly the last one of those, not knowing the basis upon which the assumption is to be treated. It may be of legal advantage in that you don't have to argue about the legal principle, but you don't have the underlying facts, and as the fact-finding judge later on will then be at a disadvantage in not knowing, in a highly fact-sensitive contextual context, how to treat the evidence in relation to disembodied B and C.
Well, I'm so sorry, Lord.
No. So I mean, I'm just trying to move the perspective. You're clearly concerned for the for the party you represent. One has to look at it all ways round, but in the end, the court has got to reach a fair view on the evidence in relation to any matters that it has to find facts on. And so the question which we need the help of the parties on is whether that is a viable process if one simply has an unpopulated assumption. Well, as I put, an assumption unpopulated by facts.
My Lord's point is, I think, the very point made by Lord Justice Chadwick and Lady Justice Arden in the Royal Sun Alliance case that we refer to in our...
But I should say that our tentative view is that this appeal is not going to fall to be decided on generalities as to whether it's a good thing or a bad thing to have mixtures of findings and assumptions that the court management, the case management decision, the court is bound to look at the particular set of facts in front of it and work out what is fair, what is efficient, and all of those matters. So I don't think you'll find that we're going to be approaching it from the basis of
fairness,
from the basis of a generality about what is and what is not an acceptable case management decision. But well, I understand you make the point that there's an instance.
Indeed, and indeed this court put in similar difficulties to the court below with an unpopulated assumption in the event of an appeal.
Mr. Marshall, can I just ask this? You've identified the knowledge ingredients of the unconscionability claim.
Yes.
3 different knowledge requirements. But it doesn't end there, does it? Because there's an overarching question of whether it would still be unconscionable for the Post Office to rely upon the settlement deed in all the circumstances. Is that right? Is there that further overarching question?
Well, I think the approach is identified. I don't want to avoid your Lordship's question, but the approach to that question is identified by Lord Nichols and Lord Hoffman in the BCCI case, and Lord Hoffman in his speech expressly refers to the Vice-Chancellor Scott's judgment in the same case below as identifying the approach. And I think the answer to your Lordship's question is once the knowledge of the claim is made out, the ignorance of the party seeking to avoid the general release is made out, and the knowledge or, quotes, awareness of the party relying on the general release is made out. Once those tests or those criteria are satisfied, I think both Lord Nichols, not in terms, but Lord Hoffman in terms, says that in those circumstances it would be, on the face of it, unconscionable to take the benefit of the general release in the face of that ignorance. And Vice-Chancellor Scott in BCCI below equated doing so, that is, enforcing the general release in circumstances of that kind, as being, in effect, dishonesty. Can I take you to the...
Yeah, the question I've got is, might it not be a relevant factor or relevant to inquire as to the extent of the defendant's knowledge, who within the defendant knew what, and the extent of their knowledge as part of that question? Because, I mean, if it is, then all the discovery, disclosure, evidence that you're concerned would be in any way on that question.
Well, and that may be the answer to it, that in order for Mr. Castleton to establish what the Post Office knew in 2019, it is necessary for the Post Office First Respondent to give disclosure in relation to its knowledge over time, because I'm perhaps stating the obvious, but we're concerned here with knowledge in 2019 on the part of the Post Office of events that occurred in 2006 and 2007 at the time of the claim and the judgment given against him. And as I sought to touch upon in the revised skeleton argument, the question of what the Post Office knows is not a question of what individuals knew at the time. It's not a question in 2019 as to whether any of those who were engaged on behalf of the Post Office in settling the group litigation actually knew or had individual memory in relation to events that occurred in 2006, but whether the Post Office, by the application of rules of attribution to corporations, is to be held to have that knowledge as a matter of corporate attribution. And therefore, in order to get to that later point, that is the position in 2019, it's necessary to evaluate and to know how the rules of attribution engage with individual knowledge over time, so it can be attributed, or so it can be said to be attributed to the corporation. And of course, we're talking here about, as in the case of prosecutions with Mr. Castleton, a claim brought against him by the Post Office as an institution, not by individuals. So we say that from the outset, from the time in which the claim was brought against him, and the various aspects of that claim and what knowledge was suppressed, we say that it's fairly easy to attribute that knowledge to the institution, to the Post Office itself. But then the question over time is, and it becomes quite a complicated issue by the time you get to 2019, how is the knowledge over time to be attributed to the Post Office in 2019? And we say that that requires a proper disclosure exercise of exactly the same kind that would otherwise be undertaken in relation to the knowledge under the first part. I don't know if that answers your Lordship's question.
A corporate body can only have knowledge by attribution of knowledge of individuals. So the first question is, did particular individuals have the relevant knowledge? And that's going to be part of the inquiry. But can I ask you this? When we talk about knowledge on the part of the Post Office of claims, is it right that what needs to be established is knowledge, I'll come back to that, of viable claims rather than valid claims? In other words, it's not necessary for you to show that they knew that there weren't necessarily good claims, but that they knew that there were at least arguable claims. Is that your case?
Well, we say viable claim, viable
yes,
claims.
Meaning
yes, arguable,
not
arguable.
valid.
The facts that, on the face of it, may give rise to a cause of action. Yes.
May give rise to a cause
yes.
of action.
Yes.
All right. And then when we talk about knowledge, which can be a very thorny
Indeed.
concept, does that encompass belief that there are viable claims, belief there may be viable claims? What do you say is the test for knowledge for unconscionability?
Well, I think the speeches in BCCI use the expression awareness, and of course that may be raise yet a further question.
Well, I mean, this may be a point in your favour, rising out of the point that my Lord was putting. Ultimately, the test is one of unconscionability.
Yes.
In this sharp practice.
Undoubtedly.
And if there are degrees of belief, certainty, awareness, they may be nuanced questions which simply feed into the ultimate question.
Yes.
Of, would it be unconscionable?
Yes.
To allow reliance on the settlement deed?
Well, Lord, I'm grateful, and in a sense, the answer that I would give provisionally is I can't say more than this, an awareness that may be less than conscious knowledge, but going to use an alternative synonym, which is a perception, but again, that doesn't perhaps advance it too much, but less than concrete knowledge of a recognised cause of action.
I mean, the law's been around the boys on this in relation to constructive trust and Bard and Delvaux and so on, and ultimately settled on unconscionability as a general concept, rather than slice it into different kinds of knowledge, blind eye knowledge, and so on. Is that also the concept that applies in relation to this sharp practice?
Well, one of the points I was going to make is that part of the problem confronting Mr. Castleton is that the law and the application of the sharp practice unconscionability doctrine, as identified and articulated in BCCI, is not worked out at all in the decisions. So your question to me, my lord, what is the answer? Well, I'm not sure that this is the right circumstance in which to settle on a final formulation of what is in fact required. There's a question.
I understand that. The reason for my inquiry is simply whether the different nuances that there might be as to knowledge or belief for the purposes of deciding what we'll do for the law on unconscionability are not hard-edged questions, which are necessarily appropriate for assumptions rather than findings. I mean, that's where
well, if I might,
that's where my mind is travelling.
Well, my lord, I would accept and adopt that, if I might, that the issue, in a sense, the answer to the question is it is fact sensitive and depends on the circumstances at the relevant time. And a broad assumption, to adopt the Lordship's earlier observation, is an unpopulated assumption without content in that regard.
Thank you.
My lord, may I turn then to the immediate ground 6 of the grounds of appeal and what we say about that. That's Annex 2 to the order made below at page 117 of the bundle. I don't want to devote too much time to this, as it were, seriatim, but I do want to suggest to your lordships that, as I was going to say earlier, something has gone wrong here, and in a sense, we're all here because on the face of it, something has perhaps gone wrong. But under the Annex 2 phrases and paragraphs that were exempted from the requirement for the first respondents to plead to, I'll just take paragraphs 11 and 12 to show you, by reference to my lord's point earlier, to the footnote on page 116 to Annex 1 to the order, why this has gone wrong, apart from other things. I'd like to start with just to show you how this issue first arose, without being unkind to my learned friend Mr. Bailey. The proposal for the way in which the court ultimately ordered that these issues were to be determined was first presented and identified in the supplemental bundle, if I can invite you to look at that, at page 191. This is the first time it was identified, that is on exchange of skeleton arguments. And to take a point against myself, I hadn't actually picked up the significance of that second footnote at the time of the hearing on the 23rd of January. And I'm only comforted by the fact that Mr. Justice Trower, in argument, said that he also hadn't spotted its significance. But paragraph 5.2, the learned friend says this: extension of time and pleadings. In advance of that split trial preliminary issues trial, the defendant should be only be required to file defences in respect of the issues for that trial, i.e. to Part A of the particulars of claim, save for a handful of sentences identified in the draft order filed with the skeleton argument, which go to the substance of the historic claims rather than the Part A claims. We submit that that's simply wrong, as I'll seek to show you in a moment. And the rationale for that is that it's simpler to proceed in this way.
When you say it's wrong, it's the statement that it's only relevant to the historic claims rather than to the Part A claims. Is that the wrongness that you assert?
Yes, absolutely.
Right, thank you.
And if I can ask you to look at page 117, and then, as it were, keeping that, look at page 141 of the bundle, which is where the relevant paragraphs are set out. As you'll see, if I'm not perhaps stating the obvious, both paragraphs 11 and 12, the respondents are exempted from having to plead at all to those paragraphs. But reading from paragraph 11 to start with, page 141, at the date of the settlement deed, the claimant did not know and could not have known, but the first defendant did know that the first defendant had combined with others to injure the claimant by abusing the process of the court for the collateral unlawful purpose of obtaining judgment against the claimant without expectation of recovering any net financial gain, in circumstances in which the defendant's counsel described the litigation as madness, and its solicitor had said of the first defendant's claim against the claimant, if you look at the case in isolation, it is completely nonsensical. So that's the first sentence, perhaps a rather long sentence. But the point that I make, and your lordships will have it already, the very first line of that is, at the date of the settlement deed, the claimant did not know. The respondents are relieved from pleading to that, but under the footnote to the order at page 116, the sub-issues for determination by way of preliminary issues are: did the claimant know of those claims? His explicit pleading is he didn't, and the respondents are relieved of pleading to that. And you have the same point, my lords, in relation to paragraph 12. Further, at the date of the settlement deed, the claimant did not and could not have known that Mrs. Anne Chambers, a system specialist employed by the second defendant's system support centre, who gave evidence for the first defendant at trial, had been instructed by her managers that she should not refer in her evidence to the second defendant's known error log that was maintained by the Service Support Centre. Neither could the claimant have been aware that following judgment in January 2007, Mrs. Chambers had communicating her concern that Fujitsu made a major legal blunder by not disclosing all the relevant evidence that was in existence. My lord, one of the most extraordinary, well, that's hyperbolic, a striking feature of the evidence before Sir Win Williams in the inquiry was that Mrs. Chambers gave evidence over several days to him. And in the course of that evidence, she gave evidence to Sir Win that she was told in terms, she believes by her line manager, not to make any reference to the known error log. This is in 2006, when we know from Mr. Justice Fraser's Horizon Issues judgment in 2019 that the known error log was the fundamental document that enabled him to reach his conclusions in relation to the Horizon issues. And more particularly, he devotes a substantial section of his judgment, I can't remember off the top of my head exactly how many paragraphs, but I think it's about 8 paragraphs, to describing the way in which the disclosure of the known error log before him in the group litigation was contested and resisted by the Post Office on grounds, first of all, that there was a question as to whether it existed at all. Secondly, when it was identified that it did exist, it was denied as to its relevance, and the Post Office, by its counsel, described the request for the known error log as a, quote, red herring. And thirdly, when it was established that not only did it exist, but it was relevant, then the first respondent's response to that was that it was not in its power to disclose. Eventually it was disclosed, and Mr. Justice Fraser describes it as being the first occasion on which the known error log, which contained, perhaps I'm stating what's very well known and clear, contained tens of thousands of records of bugs, errors and defects in the Horizon system, maintained by the second respondent from the date on which the Horizon system was rolled out in 1999. So we have here in this second paragraph, under paragraph 12, the explicit averment on behalf of, by Mr. Castleton, that he did not know and could not have known about Mrs. Chambers being instructed not to refer to the known error log. And the result of the order made is that the respondents don't have to plead to that knowledge, but he's got to establish it. The question is, if it's an issue, he's got to establish it. Why are they not required to plead to it? And in my submission, the reason for that, and I think the simple reason is that when these directions were adopted, they'd been identified for less than a week since the exchange of skeleton argument, and they hadn't received the scrutiny and attention that ordinarily agreed lists of issues or assumed facts received between the parties. Further, as it was my submission before the court below, and I don't obviously want to revisit that, but ordinarily on applications for the determination of preliminary issues or split trials, the application is initiated by one of the parties. In this case, there was no application. The court took it by its own motion and wished to be addressed on the appropriateness of determining preliminary issues and or a split trial. And it was Mr. Castleton's position that because everything was so interlinked over time, the determination of preliminary issues was not appropriate because, to use a very familiar expression, there was no real bright line separating the issues.
You lost on that, and you haven't got permission to appeal on that.
No.
Can I ask you, just in practical terms, how Annex 2 came to be formulated? The principle seems to have been that the result of the decision was that there shouldn't be required to be pleaded to those parts of the pleading in Part A that were outside the scope of the preliminary issue. Now, you say that if you look at the first bit of paragraph 11 and the whole of paragraph 12, they don't fall within that categorisation. But how did they come to be in Annex 2? Was there any judicial consideration of the terms of Annex 2, or was it just agreed as part of the drawing up of the order after the hearing?
It was just agreed. I think I can say without fear of contradiction that there's no reference to them in the judgment, and they weren't the subject of analysis or discussion or debate before.
So you agreed to Annex 2 being in this form?
I didn't oppose it, yes.
And your point, as I understand it, is looking at the first 2 lines of 11. The first part, the claimant did not know and could not have known, is wrong because that, on any view, is within that is to be determined in the preliminary issue. But the words, but the first defendant did know, it's correct that those are out if the preliminary issue proceeds on the assumption. And but you complain about that as well, I think. That it shouldn't be on made an assumption.
Well, that's our overarching point, yes. But it's inappropriate. Well, we submit that it doesn't work when you place the assumptions against what Mr. Castleton knows, I'll start that again. When you place the assumptions made in respect to the first element of unconscionability, and then against that you have the third element, which is that the Post Office first respondent knew, in relation to Mr. Castleton, knew, I'm putting in inverted commas, was aware, believed, knew that Mr. Castleton did not know. And we say there's a mismatch here between the assumption on the one hand, I'll say the unpopulated assumption on the one hand, and on the other hand, Mr. Castleton is required to demonstrate positively that the Post Office knew, was aware that he did not know. We say there's a mismatch there, and it feeds into the exercise that has to be undertaken in relation to disclosure and so on. My Lords, I've addressed what we consider to be the problem in relation to ground 6.
But so, just sorry to hold you up at the moment, but there's cross-examination of witnesses put forward by, for example, the Post Office on this third issue that you just touched on, their knowledge of his knowledge.
Quite.
Right. And so some questions are in bounds, which are strictly about that, but no contextual questions can be asked of those witnesses in relation to the first issue, which is under the blanket of an assumption.
Your Lordship, exactly right.
So because if, in order to discharge the burden that you say falls on you under this third matter, you might be wanting to ask many questions about the context in which all of this arose, going back in some cases many years. Are you to be allowed to ask those questions, or are you to be stopped?
Well,
under the current.
Well, I anticipate that they would be said to be those are assumed against the first respondent, and therefore the ingredients of the particulars of claim, the factual ingredients, are not open to be questioned, because the assumption is made. This is Mr. Bailey's essential point. The assumptions are made to the benefit of Mr. Castleton, not to his disadvantage, and for reasons that I've identified a moment ago, we say that's wrong.
It might be said that if the question in issue, leaving aside the assumption, which is one of mixed law and fact about knowledge of the corporation, if a particular individual being cross-examined is saying they didn't know something, as a Post Office witness, you would say, I think, that the knowledge of that person may well be relevant to the question of Mr. Castleton's knowledge, because what he knew may have an impact on that. Why couldn't you ask the question? Because it's relevant to the issue which is still in play. And to give an example, the witness might say, this matter was common knowledge, so of course Mr. Castleton would have known that. And you might want to cross-examine him on the basis that it wasn't common knowledge. You knew this because of a particular document.
I can see that might not be objectionable in those circumstances. Yeah. Or that no objection could be taken to it in those circumstances, if it was an issue.
The way in which it might be put is, you're asking a question to a witness who says, well, I don't know that. The issue being, what did Mr. Castleton know? And it would be a normal process of reasoning to say, well, let's see what you did know, in order that you say you didn't know at this point. And so at the moment, I'm not quite sure how that is policed, because it would seem to be a perfectly reasonable thing for an advocate to ask a witness who expressed ignorance of something to establish what in fact they did know, and that goes back into the first question.
Well, I can see that, my lord. I'm not quite sure what the answer to it is.
No. All right. Thank you.
So I was going to.
And I thought you were going to say, if that is the position, what on earth is the point of having an assumption? Because you're going to have disclosure in relation to, or potentially, into what the relevant witnesses knew about the viability of the claims, if and to the extent that it's relevant to their knowledge of the claimant's ignorance. So you're not actually saving anything in terms of disclosure or scope of inquiry.
Well, my lord, that was,
and therefore there's no advantage in it at all.
My lord, that was my first point, really, in a sense, that the making the assumption against the post office in the first instance for the first part is all very well and obviates the requirement for the disclosure exercise and so on that the post office took as its objection to a factual investigation or the reason for the assumption. But of course, once Mr. Castleton is in the position of having to demonstrate what he actually knew about his absence of knowledge in relation to those claims, you're into precisely the same exercise, and it can't. So the saving in relation to the first issue doesn't feed into the third issue. But I'm not sure I can help the Lordship further on that. My Lords, can I, having considered the schedule of the pleading issues, I was going to turn to the hybrid approach and, so far as not already covered, explain what Mr. Castleton's position on that is. And it may be of assistance to your Lordship to pick up one of the questions earlier to look at the first authorities bundle in relation to the formulation of the doctrine under BCCI at tab 7, page 118. I'm sorry, that's the Court of Appeal decision. Page 158. And your Lordships no doubt will recall that this well-known case was about the novelty in relation to a claim that was said to be barred by a general release of a claim for stigma damages in relation to the former employees of BCCI. And perhaps the best known formulation of the doctrine, when it was, I think, first articulated in this way, is in Lord Nichols' speech following his review, his consideration of the approach, the correct approach to the construction of settlements, and in particular specific and general releases. And very briefly, at paragraph 32, he articulates the doctrine as in this way. Thus far I have been considering the case where both parties were unaware of a claim which subsequently came to light. Materially different is the case where the party to whom the release was given knew that the other party had or might have a claim, and knew also that the other party was ignorant of this. In some circumstances, seeking and taking a general release in such a case without disclosing the existence of the claim or possible claim could be unacceptable sharp practice. When this is so, the law would be defective if it did not provide a remedy. Lord Hoffman's speech, which is rather more extensive in relation to this issue, it is at page 186 and paragraph 69 of the same judgment. And Lord Hoffman says this: "My Lords, I think that this argument presses the principle in Bell and Lever Brothers too far. It was not a case concerned with a general release. A transaction in which one party agrees in general terms to release another from any claims upon him has special features. It is not difficult to imply an obligation upon the beneficiary of such a release to disclose the existence of claims of which he actually knows and which he also realises may not be known to the other party. My Lord Justice Popplewell's question earlier as to what the relevant knowledge may be, he puts it in the terms that may not be known, may conditionally not be known. There are different ways in which it can be put. One may say, for example, that inviting a person to enter into a release in general terms implies a representation that one is not aware of any specific claims which the other party may not know about. That would preserve the purity of the principle that there is no positive duty of disclosure. Or one could say, as the old Chancery judges did, that reliance upon such a release is against conscience when the beneficiary has been guilty of suppressio veri or suggestio falsi. On a principle of law like this, I think it is legitimate to go back to authority, to Lord Keeper Henley in Selkeld and Vernon, Eden reports, where he said, no rule is better established that every deed obtained on suggestio falsi or suppressio veri is an imposition in a court of conscience. Is an imposition in a court of conscience. Paragraph 70. In principle, therefore, I agree.
Do you want us to read paragraph 70?
Yes, and if you would.
And 71, yes.
Thank you very much.
Thank you.
And his approval of Sir Richard Scott's Vice-Chancellor's judgment below is in the bundle at page 129 at paragraph 30. I'd just invite your Lordship.
To what extent do we need to go further into this than you've already...
Well, simply that Sir Richard Scott in that, in his judgment there, describes the reliance on the release as dishonest, which doesn't appear in the BCCI decision. But
all right.
Anyway, your Lordships have it.
Well, Sir Richard Scott puts it in terms of the party acting dishonestly.
Quite.
Which is a much higher test than certainly we see in Lord Nichols.
Exactly. Paragraph in my note, I was going to submit that without trespassing on the scope of this appeal, the court may consider the issues of what the first respondent knew or did not know at the time of the agreement in December 2019 in relation to Mr. Castleton's claims may not be easily isolated or extracted from the wider context of the long and extensive history of concealment of information. It is not irrelevant that on the Horizon Issues trial in 2019, the first respondent prayed in aid the judgment of His Honour Judge Havery given in 2007. No challenge was made by the claimants in the Horizon Issues litigation to the validity or the circumstances in which that judgment had been maintained. A further point in relation to the terms of the order made below is that in the schedule at the footnote,
it's 116.
I'm obliged. in the footnote, the first part of the footnote provides as follows. For the avoidance of doubt and without the first defendant or the second defendant having made any admission, this issue shall be determined on the provisional assumptions for the purposes of the preliminary issues trial alone. Perhaps it's a small point, but just as an indicator of the perhaps lack of care with which this footnote had been originally drafted, it's not at all clear what is meant by the provisional assumptions there for the purposes of the preliminary issues trial alone. I take it that it's not meant that the provisionality there relates to the assumptions solely for the purpose of the, I've put that wrongly, incorrectly. It can't be intended to mean by provisional there that after determination of the preliminary issue, assuming that were to be decided against the first respondent in favour of Mr. Castleton, the first respondent would be able to say thereafter, well, that was only a provisional assumption we made for the determination of the preliminary issue on the assumed facts. Actually, the assumption that has been made is not one which is valid because, in truth, we contend that the knowledge was less than the assumption that was then made against us. If it doesn't mean that, and I can't see how it could operate in that way, as it were, to leave the gate open to change the position subsequently in relation to the assumption, it's very difficult to see.
Is the point for our purposes that we don't know whether the gate is being left open or not?
My Lord, I went...
I mean, is this a convenient moment to ask? Mr. Midwinter says, no, the gate isn't being left open, but what matters is what the post office is saying. What was the position, Mr. Bailey?
My Lord, could I just ask you to restate the point?
Yes.
Question.
Are you, by that reservation, reserving to the post office the right after the determination of the preliminary issues, if it is still a critical point, which it may be on certain findings, to say the preliminary issues were only made on an assumption as to the post office's knowledge as to viable claims, and we now want to have that determined as a matter of fact that the relevant witnesses whose knowledge is to be attributed did not have knowledge of viable claims.
Yes, my Lord. The way we would put it...
You do want to be able to say that later?
The way we would put it is to say that there are 4 ingredients to the doctrine, and we seek to effectively succeed on either 3 or 4 at the preliminary issue. If we are unsuccessful on those, such that the sharp practice argument is then run at a final trial, it would be open to post office to say, as to ingredient 2, it seems that there was an underlying claim per ingredient 1, but as a matter of attribution and possibly corporate amnesia, post office did not know on the 10th of December 2019 of the existence of the historic claims, and therefore the doctrine of sharp practice should not be permitted.
Yeah. So Mr. Midwinter is wrong in attributing to you, at least, the suggestion that assumption in Roman 2 will, or the ingredient, which is the subject matter of the assumption in Roman 2, Mr. Midwinter says can never arise for determination in the future. You, on the other hand, are making clear by this that you are reserving the position to revisit that question as a matter of fact, should it be critical to the question of whether the deed of settlement settles the claims.
My Lord, indeed, and I had an opportunity to speak to Mr. Midwinter about that, and it may be that he does not intend that sentence to mean precisely the way it has been.
All right, but anyway, your position is clear. Thank you.
Indeed.
All right. So the gate is open.
Well, my Lord, in which case I have to ask rhetorically, what is the point of this exercise if it's determined on an assumption against the first respondent that the general release doesn't bite for reasons of unconscionability or sharp practice, however it's characterised. If the position subsequently may change. The litmus test, I understand it's submit, for the determination of preliminary issues, in particular, is that they should be dispositive of the issue one way or another. And if that is the case, that it's simply not, well, as I understand it. And for that reason, in addition to the others that I've identified, objectionable. But it's not a submission that I've made previously, so I'll make it.
Excuse me.
Mine.
Sorry for interrupting you. Yes.
Well, Lord, I was going to make the general point, and perhaps it's clear enough in my previous submissions, but we say that it is arguable, and we put it no higher than that for present purposes, that the issue of attribution of knowledge to the Post Office in 2019 about what Mr. Castleton may have known or not known about claims that he might have against it may well be difficult to disentangle from the first respondent's wider conduct in concealing and suppressing its institutional knowledge over time, and the level of those individuals who had actual knowledge at material times within the Post Office so as to be attributable to it. And can I just, in relation to that, make an observation, another one, in relation to what has emerged in the inquiry, and your Lordships will have it from our particulars of claim, that perhaps some of the most striking evidence to emerge in the inquiry was given by the IT expert appointed to the inquiry, Mr. Charles Scipione, who in his reports to the inquiry explained that he had been struck, I think that's his expression, that in 1999, when Horizon was first rolled out to the Post Office's 17,000 branches across the UK, what Mr. Scipione calls gating issue, that is a contractual threshold issue, for acceptance and indeed payment of the first instalment by the Post Office to what was then ICL, became the second Respondent, was that it was recognised and known that the Horizon system then had a propensity to generate cash account discrepancies at branch accounts, and it had to be contractually negotiated and agreed that within tolerances that would be acceptable performance of the supply contract by ICL.
This is part of a very wide picture, but is your essential point that there is a history here? This is. I mean, the parties are not arriving at court to deal with this litigation from a standing start. That there is a very well-known history here, described by the judge in the two big judgments, and that is the overall context in which you say you shouldn't be prevented from drawing from that history when, for example, making submissions about the credibility of individual witnesses about what they knew and didn't know.
My Lord has the point.
Right.
My Lord, I've taken an hour and not addressed you on the amendment to the skeleton argument,
Well,
for which
I think
15
the way
minutes
which
were allocated.
I'd suggest we deal with this, my Lord will intervene if they think better of it, but is that we should probably hear from the respondents and give you an opportunity to deal with that in response in relation to any matters that are concerning us. Would that be a way of dealing with it from your point of view?
Most grateful, my Lord.
All right. Well, if that concludes your presentation, we'll take a brief break now for the benefit of the transcriber, and then hear from Mr. Bailey, Mr. McWhirter. Thank you.
Court rise in favour. advised in favour.
My lords, I apologise for...
Not at all.
My lords, it's useful perhaps just to take a short step back to recall the purpose of the preliminary issue trial and why it has been ordered. My intention is to focus my submissions in reverse order a little bit, as my learned friend did, to focus on the point that the court wishes to focus on and then come back to issues such as scope thereafter.
Yes.
The purpose of the preliminary issue trial was and always has been to try to find an effective way of getting to a resolution, a disposition of the matter, both as a matter of cost and time. It is useful to have in mind how the three parts, or the three claims within Part A, sit together. The first claim is one of construction, and construction has two threads to it. It has the specific release argument and it has the general release argument. The second claim, which is sharp practice, it is agreed between the parties, only goes to the general release. So if Post Office is right on specific release, then sharp practice has no application to the matter at all. And then the third claim is one of the misrepresentation concerning the reasons for not calling evidence, and that is an attack on the settlement deed in its entirety. The doctrine of sharp practice you have been taken to already at paragraphs 32 and paragraph 70 per Lord Nichols and per Lord Hoffman in BCCI and Alley. And what is identified in both those passages is that there are four ingredients which need to be established in order for there to be the possibility of sharp practice unconscionability featuring. It is then supplemented in practice by the later decision in the Maranello case, but it might be right to say that rather than being a fifth ingredient, that is a rider that attaches to it. That may be a matter of semantics. Those four primary ingredients are important to consider carefully. The first one is whether the claimant had or might have had a claim against the defendant. We say there's no particular difficulty in that assumption. That's what happened in the FII case, for example, where the existence of the underlying cause of action was assumed for purposes of dealing with the limitation point. As I understand, my lords, that's not the part that might be troubling you. The second ingredient is whether Post Office knew of the claim or the potential claim. So this is knowledge of the historic claims, of what is in Part B and what is in Part C. And it concerns what Post Office knew about itself. It is about its own internal knowledge of the events pertaining to and the consequences of the events pertaining to 1999 to 2007. The third ingredient concerns not Post Office's knowledge, Mr. Castleton's knowledge, and is therefore a very separate inquiry, and asks the question as to whether or not he was aware or unaware that he had these historic claims. And then the last ingredient, whether the defendant knew of the claimant's unawareness, is indeed a knowledge question that falls back onto Post Office, but it is a different factual inquiry. This is about whether, on the 10th of December 2019, Post Office had reason to believe, or was on notice, the way the law is put on this at the moment is unclear, but knew of Mr. Castleton's unawareness specifically, his unawareness of his claims. So it is quite a narrow factual inquiry. And then finally, there's the supplementation in Maranello, which I shall come to. Therefore,
sufficient, at least arguably, if they had reason to believe or were put on notice of Mr. Castleton's ignorance of his claims. Is that what we should
my Lord, yes. And one of
purposes?
my Lord, yes. One of the realities of the situation we find ourselves in today is that a lot of weight is being put on the doctrine of sharp practice in circumstances where that doctrine perhaps still needs to be fully developed. My Lord Justice Popplewell has already identified the complexities of knowledge, and I would respectfully agree with all that is said. Neither Lord Hoffman nor Lord Nichols explain in any detail at all what knowledge test they had in mind, and that is a matter that may well need to be determined in due course. However, the logic map of sharp practice is that in order for Mr. Castleton to succeed in applying the doctrine, he will need to succeed on sharp practice issue 1 and 2 and 3 and 4 and circumvent any problems with Maranello and number 5.
So I just spell out for you. Maranello is, the rider in Maranello is what?
The rider in Maranello, which I'll come to in a bit more detail, but to answer my Lord's question now, that is that if the general release is construed so as to release unknown claims in fraud, it simply cannot be unconscionable to complain that it has released an unknown claim in fraud, because that is precisely what the settlement agreement properly construed did. And I'm going to take my Lord to that decision because it's extremely important, because I think it may answer any concerns which your Lordships have, because in effect what's happening here is very much the same as what was happening in Maranello. Because Mr. Castleton would need to succeed on all 5 points in order to be able to deploy sharp practice, it is sufficient for Post Office, and indeed Fujitsu, but predominantly Post Office, to therefore only have to win on any 1 point in order to shut out the possibility of that doctrine being deployed, assuming that Lord Hoffman and Lord Nichols' formulations of it, which appear to be consistent with one another, is right, and we say that that is the right way of viewing it, at least for the purposes of today. The question therefore becomes, in order to have a sensible and practical preliminary issue trial in circumstances where, as Mr. Justice Trower found below, there was a great deal to commend it with regards to saving time and cost, is there a way of formulating the scope of those 5 issues so that the preliminary issue trial does not expand or explode into a detailed consideration of what was going on in 2006 and 2007, which would be extremely unappealing and indeed may end up with a solution which is impractical. Accordingly, what Post Office has sought to do is to simply confine its attack on the application of the doctrine at the Part A trial to 2 particular ingredients, ingredients 3 and 4, and then seek to rely upon Maranello, which may have application once the court has determined Claim 1 and the true meaning of the general release has been determined. Now, in Maranello, something very similar happened, and I'm going to invite my Lords to turn up that decision. It is in our authorities Bible. I'm going to ask the court please to go to page 1098. Now what was, and this is from paragraph 65, but if I can give the court just a little bit of context to begin with. In that case, Bonhams and MRL had entered into a settlement agreement, and MRL sought to contend that that settlement agreement did not extend to unknown claims in fraud. That happens to be paragraph 34, but we don't need to go there at this stage. MRL then ran a sharp practice argument and brought a claim in unlawful means conspiracy. Now, Lord Justice Phillips at paragraph 65 says as follows. I should say that having not succeeded below, MRL was trying to challenge the rejection of the sharp practice principle. MRL argues in this appeal that the judge's reasoning fails to recognise the necessarily assumed fact that the respondents knew that they had unlawfully conspired against MRL and that MRL was unaware of that conspiracy. So this is sharp practice issue 2. And what we then see at 66, Lord Justice Phillips says, in my judgment, MRL's contention fails to address the core of the judge's reasoning, namely that it was not arguable that it was unconscionable for the respondents to rely on the release as having settled claims in fraud and conspiracy. Not a case where the respondents knew that MRL had claims of which it was totally unaware. Moving on, as the judge explained in some detail, MRL was fully aware and had alleged that Bonhams had damaged MRL by acting deliberately in breach of his duties and agents, and so on and so forth. So what has happened there, to use the language, if I may, of Lord Justice Jackson with regards to the population or the unpopulation of particular ingredients. Ingredient 1 and ingredient 2 were not populated in Maranello. But notwithstanding that, the Court of Appeal was perfectly satisfied that on the facts of the case it could comfortably disapply the doctrine of sharp practice. And indeed we see at 67, I would add that where a release is construed as covering unknown claims in fraud, dishonesty and conspiracy relating to a defined subject matter as in this case, such construction entails a finding that the parties mutually intended to settle such claims. That would seem to leave little scope for a finding that one of the parties was guilty of sharp practice in relation to the existence of such a claim. So what Post Office is seeking to do in this preliminary issue trial is to accept sharp practice issue 1, which I submit is uncontroversial, to not get into what might be a complicated question as to what facts about the 2006 and 2007 claims Post Office knew, because that would necessarily involve a determination of which of those facts were relevant, which would involve an inquiry into preliminary sharp practice issue 1, claims B and C. That can't be done on a preliminary issue trial. The whole point is to separate A from B and C. What Post Office does is simply confine itself to ingredient 3 and 4. Post Office believes that it can establish that Mr. Castleton knew that he had the claims, and that will happen. The argument will be quite simple, because one will simply be looking at the content of the GLO pleadings, the GLO action. The whole purpose of the GLO action, the foundation of the GLO action, is a claim in fraud against Post Office, point identified or emphasised by Mr. Justice Trower below. So in those circumstances where the whole GLO action is being brought on the foundation of fraud, Post Office believes that with regards to looking at GLO materials, it can establish that Mr. Castleton knew of the claim. Maybe Post Office will be right, maybe Post Office will be wrong, but it is a relatively discrete inquiry. The fourth ingredient concerns the extent to which Post Office knew. Assume for the moment under ingredient 3 Mr. Castleton was unaware. The court finds that at the preliminary issue trial. If Mr. Castleton was unaware, the fourth ingredient is, did Post Office know, to whatever level of knowledge, did Post Office know of Mr. Castleton's unawareness? Now that is something which is going to rest, I would anticipate, on looking at the content of the GLO documentation. And one anticipates arguments along the lines of, given these allegations that you have made, how could you not have known of the claim in fraud, noting the 2006-2007 claim, noting that your pleadings in the GLO action are based on fraud? Now, maybe that argument will succeed. Maybe
so that's issue 3, isn't it?
I've now moved on to issue 4. So I've assumed this is sharp, beg your pardon.
Yeah.
It is preliminary issue 3, sharp practice, and it is ingredient 4 within sharp practice. So sharp practice issue 3 is whether Mr. Castleton was unaware.
Yes, I'm in your taxonomy. I was just having difficulty following why you were saying the point you was on was a sub issue 4 rather than 3 point, because it seemed to be focusing on what Mr. Castleton's knowledge was.
Yes, sharp practice issue 3 is Mr. Castleton's knowledge, but then sharp practice issue 4 will be the extent to which Post Office was cognizant.
I understand that.
of his unawareness. And indeed,
Just make the point you were making at the end. I may have misunderstood what it was about what the scope of that issue would involve in practice.
the point that
Issue
I'm
4.
seeking to make is that given the pleadings that were before the court, all of the materials that were before the court in the GLO action, it would have been, we say, quite reasonable for Post Office to look at that material and to say, we believe Mr. Castleton is aware of the claim. That's the issue. And that will have to be determined, of course, at the Part A trial. But the knowledge that's involved there about what Post Office knew was completely separate from what Post Office might have known about events of, say, 2006 and 2007. And it is not something that troubled this court in Maranello. The court in Maranello simply accepted that 1 and 2 were unpopulated, but was perfectly able to find that the doctrine of sharp practice didn't apply because other ingredients hadn't been met. Now, in this particular case, of course, being the Maranello exception itself, the disapplication of unconscionability sat on the construction of the general release.
Well, did it really? I mean, the finding in paragraph 66 was the claimant had known of this claim all along. I mean, it's the equivalent of a finding against Mr. Castleton on sub-issue 3, and it's only the rider in paragraph 67, which is something of an aside.
My lord, I misspoke. Absolutely, yes, indeed. 3 and 4 are addressed in paragraph 66, and then paragraph 67 effectively gives me a fifth hook to attempt to hang my case on at the preliminary trial. It might also then be useful to look at the other relevant decision of this court, which cited and built upon Maranello, and that's the decision in Riley and Nat West. And if I can invite the court, please, to turn up page 1352. Again, another attempt to rely on the doctrine of sharp practice to avoid a settlement agreement. And at paragraph 48, we see the grounds of appeal in that case. And we see ground 2. The judge erred, it is said, in concluding that application of sharp practice principle was capable of being summarily determined in the respondent's favour. The scope of the principle is a developing area of the law and ought not to be determined on a strikeout or summary judgment application on assumed facts. So there, being summary judgment, it seems that the factual assumptions are likely to have gone very much further still. The decision can be found at paragraph 77, or passing at 77, page 1362. We see there a quoting of the three relevant paragraphs we've just looked at from Maranello. And then we see at 79, Mr. Sinclair is right to submit that the decision of the judge does not set a dangerous precedent. The Rileys, being the appellants, believe that they had been deceived by the bank, and that the bank had engaged in a thinly disguised ploy to further its own interests at its customers' expense, but nevertheless freely entered into a settlement agreement which extended to unknown claims. The only dangerous precedent would be set in allowing them to reopen that bargain. So in this case, all of the facts were assumed, but nevertheless, the Court of Appeal considered that it was appropriate to find that the judge was right below in excluding the application of the doctrine of sharp practice. So, my lord, in those circumstances, we say that Post Office has confined itself and perhaps slightly prejudiced itself, although a cost we're quite prepared to pay, by not being allowed to run the preliminary issue trial sharp practice issue 2. But that's not something that should trouble this court. It didn't trouble this court in Maranello. And it will be perfect.
So can I just be clear, the reference to unknown claims in 79 is claims unknown to the claimant alone?
These will be claims unknown to the claimant, yes. And so, I was just, sorry, my lord, I'm just trying to remember
Sorry.
I was making. So, my lord, we say what Post Office has effectively done is confined itself to just advancing a case on points 3, 4, and 5.
Don't we have to have a slightly better understanding of what the terms of the settlement deeds were in these cases in order to draw general principle from them. In Maranello, the settlement deed included unknown claims extending to fraud.
There will be a question at the preliminary issue trial as to whether or not the settlement deed of December 2019 properly construed does or does not extend to claims in fraud. And it is right, I think, to observe that if the court found that properly construed the settlement deed does not extend to unknown claims in fraud, then I may have some difficulty in applying the Maranello rider to that case. But that does not prohibit Post Office from being able to say, when the agreement was entered into, Mr. Castleton was aware of the claim that he now wishes to bring, and because he was aware of it, it cannot be unconscionable for him to say that he wasn't aware.
But can we just, or can I just try and focus on the whether there is any overlap between your issues 2 and 4. That's the issue 2, which is the subject matter of an assumption, is whether the Post Office knew of viable claims. That's to be assumed. Issue 4 is whether the Post Office knew of the claimant's unawareness of viable claims. And the question as to, which is to be determined, and the question as to whether there is an overlap between those issues will only arise, as you've been anxious to make clear, if you fail on issue 3 as to Mr. Castleton's actual knowledge. So I quite understand that the Post Office case may be, well, that's all terribly straightforward and it'll all get knocked out at that stage, because we'll simply look at what was the subject matter of the group litigation, and it's perfectly obvious that he was aware of these potential claims. But we have to address this question on the assumption you failed on that, and that he is unaware of it, and that the of viable claims, and that the question that the judge will have to decide in the preliminary issue, which is to be decided, not assumed, is what was the Post Office's level of knowledge or awareness of his ignorance.
Precisely.
Now, if a witness from the Post Office is being asked about their ignorance of the claimant's knowledge of his claims, the witness may say, well, I didn't know that he was unaware that he had these claims, because frankly, I didn't think he had any viable claims. And then they might want to be cross-examined on that. Mr. Castleton's counsel might say, well, you say you were unaware of it, but what about this, and this? Look at this document of a meeting running up to the settlement agreement at which these kind of claims were potentially discussed. Now, would you at that stage jump up and say that's not in the arena because that's the subject matter of issue 2, which is to be dealt with by assumptions?
My Lord, no, and I believe this may be in Lord Justice Zacaroli's point from a little earlier on.
Well, it may be, but can I just then follow it through? So the answer to that is no. So there may arise circumstances at the hearing of the preliminary issue in which questions which fall under sub-issue 2, Post Office knowledge of claims, do have to be addressed, and on which the judge might have to make some findings in order to determine sub-issue 4. Are you with me so far, or would you resist that?
I'm with the meaning of my Lord's statement.
And if that is right, aren't there potentially two difficulties? One is there's going to be quite a difficulty for the Post Office in giving disclosure, in distinguishing between what is relevant to issue 4 and what is relevant to issue 2 on an ancillary basis that it may be relevant to issue 4. So that you're going to get into something of a muddle. Take the example I gave you a moment ago. The witness said, I didn't know anything about the claims. and therefore my state of mind was, of course, I didn't know that the claimant was unaware of it because my state of mind simply didn't address awareness or otherwise of the claims. And then a document is put saying, well, here's a discussion at a meeting shortly before the settlement agreement, to which he says, well, okay, but then we had another meeting 2 weeks later, at which actually, having taken some legal advice, although we were aware at that stage that there might be some claims, we'd formed the view that they weren't viable. Has that document been disclosed? Probably not, unless you are being prescient about lines of cross-examination when it comes to disclosure. But it would be a relevant document. So there's that problem, and then I'll give you an opportunity to respond. But can I just articulate what I see as another problem, which is that the judge is going to have to make findings in relation to some aspects of sub-issue 2 in order to make his findings on sub-issue 4, so that some of what is in sub-issue 2 will be in the arena. It can't all be dealt with on assumption. I finished. Just let me give you an opportunity to respond.
Might I respond to my Lord's questions pictorially through the notion of a Venn diagram? This is not, I would submit, a situation where one has one territory, which is issue 2, another territory, which is issue 4, and a hard brick wall built between 2. Rather, or sorry, I beg your pardon, I should say issue 2, issue 4, and indeed issue 3 as well. Rather, what one has is, as my Lord identifies conceptually, an element of overlap, or the risk of an element of overlap. But the fact that a particular document falls within issue 2 does not prohibit its disclosure if it's relevant to issues 3 or 4. And therefore issues 3 and 4 are capable of being explored to the extent that the document goes not to events of 2006 and 7, but goes to Post Office's understanding of Mr. Castleton's state of mind on the 10th of December 2019, and Post Office's knowledge, as at the 10th of December 2019, of what Mr. Castleton knew on that day. And in my submission, because one is concerned with such unusually separated temporal spheres, a 12 to 15-year gap between the two, we say that in reality it is extremely unlikely that there would be such overlap. But if there were to be such overlap, that is not, in and of itself, a problem. Because the fact it's relevant to issue 4 doesn't, so I beg your pardon, the assumption in issue 2 does not preclude it being considered. Now, Post Office is admittedly making a strategic decision to seek to pursue sharp practice, or its resistance to sharp practice, in the way that it does, and it bears the risk in the event that it's unable to succeed in achieving what it wishes to achieve by virtue of grounds 3 and ground 4. Post Office's belief is that it can do so, but that is Post Office's, in my respectful submission, strategic decision to try to do that.
Well, what risk is it running if, as you say, you're entitled to revisit the assumptions if they turn out to be critical?
Well, it can't revisit assumptions 3 and 4. That will be determined once and for all at the Part A trial.
Yeah, but you say the Post Office is taking a risk of challenging only these aspects for the purposes of the preliminary issue, but it's not really taking a risk, is it? It's simply keeping open for a later stage other arguments if it should turn out that they're necessary.
Yes, I mean, if anything were to go, I mean, one can perhaps see a situation where a judge might say, well, I've looked at issue 4, but I'm afraid on the material before me, which you say is the beginning and the end of sharp practice issue 4, I'm afraid I'm not able to exclude unconscionability on that basis. You have not done well enough on sharp practice issue 4. That's the end of it. I can't come back on sharp practice issue 4 again as a second trial.
No, but then you can come back on sharp practice issue 2.
I can,
You say.
which is a really much narrower point, and really all that sharp practice issue do is carving out the concept of what might be described as corporate amnesia. I think it's identified in alleging and dollar land holdings, which I'm afraid is not in your bundle, but this idea that it is possible through a change of management for a corporation to have known something at one point in time and to have not known it at another point in time. That is really what sharp practice issue 2 is preserving. And it is not something which lends itself to being determined at a preliminary issue trial, because one would need to understand what all of the facts making up the 2006, 2007 claims were before one could ascertain what Post Office knew about them.
Well, I think when you were formulating sub-issue 2, you said that was all about internal knowledge within the Post Office in relation to the period 1999 to 2007.
2007, which is the time...
What you're now suggesting is actually there won't be any issue as to what the knowledge was of the within the Post Office during that period. The only real issue will be whether the corporation still had that knowledge at the date of settlement.
Yes, first one would need to establish what its knowledge was in 2007, and then the question would become as to whether any of that knowledge had been lost by the passage of time.
Yes, so it isn't... I mean, you say you seek to portray it as though the only real issue is corporate amnesia, but that's not actually what you're saying.
It may be slightly more. So, my lord, that is how we say the assumptions operate in Annex, in footnote 1. Annex 1.
Is there also the overlap, which was discussed earlier, between issue 2 and the broader question of unconscionability, which I think you accept is a developing area of law and overlays all of this? So the court would have to be inquiring into the nature and extent of knowledge to answer the unconscionable, or may need to, for the unconscionability question anyway.
Well, except the Court of Appeal was very content to determine that it didn't have to do that in paragraph 65 of Maranello.
That's slightly different. That's a knockout blow on any view, isn't it? Isn't Maranello a knockout, if it's correct and applies here, a knockout blow to you?
67. Paragraph 67 is a knockout blow, but paragraph 67 is an additional observation made by Lord Justice Phillips, who said, by the way, I don't see how unconscionability can operate in circumstances where unknown claims in fraud have been determined or have been settled. But in paragraph 66, what Lord Justice Phillips is concluding is that sharp practice issue 3 and sharp practice issue 4 have not been made out by the party seeking to rely upon them, and therefore reaches the conclusion that there can be no room for unconscionability, having disposed of it on those two grounds. 67, from my client's perspective, is a bonus point that Lord Justice Phillips has introduced into the ingredient matrix.
But I think the point my lord is putting to you is that if sub-issues 3 and 4 are determined against you, which is the converse of the situation in Maranello, then you've got the unconscionability question, which depends upon not a black and white assumption of knowledge, but nuances of unconscionability.
My lord, yes, but we say that in all the circumstances given...
Sorry, I'm so sorry. Maybe I haven't thought this through. Are you saying that the judge is never going to get there on the preliminary issue if the claimant has won on issues 3 and 4, because those will be the circumstances in which your assumption isn't going to be effective, and that issue will have to be determined, and that will have to be left over for another day?
Yes.
So unconscionability is also potentially something that is not within the scope of the preliminary issue, you say? Certainly not apparent from the order.
Sorry, my lord, I'm not quite sure.
Well, it may be my fault. Let me try and spell it out again and see if this is the point. If the claimant wins on sub-issues 3 and 4, then the preliminary issue, as currently formulated, as it seems to me, envisages that the court was going to decide questions of unconscionability as an evaluative assessment, wherever the law may be on that, and it's developing area. But I think what you're saying is, no, you will say to the judge, if that's where you get to on sub-issues 3 and 4, you can't go any further. You can't actually decide the preliminary issue on the sharp practice point, assuming it's determinative, because until the assumption in sub-issue 2 is investigated as a question of fact, you won't be able to decide A, whether that ingredient is made out, or B, whether it's made out in a way which attracts the epithet of unconscionability.
The only part of unconscionability that would be left open would be an argument based upon sharp practice ingredient, assuming sharp practice ingredient 1 is made out, would be on ingredient 2.
Well, in that case, the order which I'm rereading as this discussion is going on says that there is going to be, paragraph 2, a trial to determine the issues set out in Annex 1. And point 3 of that is preclusion of yourselves on grounds of unconscionability. That's what that's the package. And you're now telling us that it isn't the package.
Well, my lord, what we had anticipated and indicated below was that that we would not be able to run sharp practice on 3 or 4 or indeed 5, because of course the settlement deed would have been construed. The only possible variation that was left in play was whether or not Post Office did or didn't have sufficient knowledge under ingredient 2.
Well, to put it another way, the carve-out in footnote Roman 2, the carve-out of that being an assumption, is not only a carve-out that allows you to revisit that factual question later, but is a carve-out that enables the unconscionability question to be addressed in the light of the answer to that question.
My lord, yes.
Unless you've had a knockout blow at other stages.
Yes, I mean, one can, yeah, indeed. I mean, we are, as I said, attempting to succeed on 3 or 4 or 5. But if we are unsuccessful on those, we're not going to be able to run those again. But there is at least a conceptual possibility that by introducing a new finding, which is Post Office's, the state of Post Office's knowledge about the 2006-2007 claims by way of sharp practice issue 2, that the door may be ajar to say, well, in fact, sharp practice is still is a doctrine that cannot be relied upon. That is the way that we had intended to formulate it. And indeed, that is why it is an assumption only for the purposes of the parte trial.
Is there a risk of inconsistent judgment? Suppose that, although you say the risk of overlap is not very great, there is a risk of overlap. Suppose that the judge, on this occasion, does make some findings on issue 2, Post Office's knowledge of viability of claims, for the purposes of deciding sub-issue 4. And then we get to the stage where what the actual position is under sub-issue 2 matters, because that's the way things have fallen out, and the carve-out comes into focus. By which stage the judge has died or moved on or whatever, and that will be decided by a different judge.
My lord,
I mean, issue estoppels are probably not going to provide the answer in relation to nuanced findings of evidence, are they?
well, if a court has made a finding of fact in the preliminary issue trial between the same parties to the litigation, we're surely bound by it. We can't.
Yes, but it's not a true finding of fact.
And it's not an issue estoppel.
It's in a sense that the whole point, as I understand it, of this very high-level case management decision was to limit the amount of evidence that was appropriate to the issues that was going to be decided. But the assumption, if as soon as there's any finding of fact in relation to matters falling under the second limb of unconscionability test, how can you sort of tiptoe into it as part of an overlapping piece of a Venn diagram and prevent access to the whole of the hinterland of that circle in the diagram as to what that might say? I mean, to give a practical example, which has troubled me, I share with you, that you've got a witness who's saying, I did know or I didn't know something about one of the issues that is going to be tried. How are we to deal with the situation when they're asked about their general credibility in relation to what was and was not known? How could they be prevented? How could the court prevent them?
Because, my lord, the inquiry which would be taking place at the preliminary issue trial of that witness would be, did you know, what did you know about, or did you know of Mr. Castleton's unawareness or awareness of his claim? It's about Mr. Castleton's state of mind.
That's right, but how is it? I mean, let's suppose this witness is somebody who has a long involvement in the case. Is it suggested that they can't be asked about the satisfactoriness in your case, or the unsatisfactoriness in the claimant's case of their evidence in relation to other matters? I mean, this is in a context where there have been an awful lot of credibility issues. So how is that to be dealt with?
Well, the witness statement that one anticipates that would be given, if a witness statement is given by post office on the point, the evidence would address the basis upon, or the understanding that post office had, if any evidence is adduced at all, as to what it believed Mr. Castleton knew of his claims, which, as I
understand what the subject matter of it is, but I'm thinking about it from the angle of assessment of the witness.
Well, an inquiry, a line of questioning which goes to credibility is something which one anticipates, or at least within reason, would be permitted by the trial judge.
But how can you cross-examine as to credibility if you don't have the documents?
Because one would anticipate that the credibility would be explored within the context of Mr. Castleton's knowledge of his claims, rather than attempting to go back, for example, some 20, 25 years. That would be a very broad exercise of a discussion, to say the very least, by the trial judge, to allow a cross-examination on credibility that effectively roamed completely free in circumstances where the issue that the court will be trying to get to would be the question as to what Mr. Castleton knew, and more importantly, what Post Office knew about what Mr. Castleton
I understand.
Sorry, Mr. Bailey. I'm sorry, but I need to go back to my question, because the answer took a course which slightly took us off course from my perspective, and maybe I just haven't picked up on things, but let me try that again. I think you accept the broad proposition that the claim in unconscionability includes, as one of the things the court has to consider, the nature and extent of the knowledge of the claim of the Post Office as to the claims. So it isn't just the 4 ingredients, or perhaps 5 you enumerate, but there's an overarching question of unconscionability to be considered in all the circumstances.
My lord, with respect, wouldn't put it in quite that way. I would not say that it is overarching across all the ingredients. The state of knowledge operates within each specific ingredient. Within each ingredient, a level of where knowledge is relevant, the court will ascertain what the level of knowledge is for each ingredient. It will, in my submission, ask itself the question, for example, is the level of knowledge achieved in Sharp Practice Issue 3 sufficient to meet Lord Hoffman's test, Lord Nichols' test? I appreciate we're going to need some further definitions to what that is, but either it does meet that level or it doesn't meet that level.
Which test? It satisfies the ingredient or satisfies the overarching question? Because Lord Nichols puts it in terms of, if these things are established, it may, in some circumstances, be unconscionable. We're now at the in some circumstances stage of the inquiry.
Yes, but if they are, if Mr. Castleton is successful on 3 and 4,
I don't think you can answer it that way, because we won't know if he's successful on those until judgment. We're now considering the position at trial, so the investigation of all issues that might be relevant or will be relevant to the judgment overall.
At the preliminary issue trial?
Yes. So he hasn't been successful in anything yet. It's all up for grabs at the trial.
Sorry, my lord, can I just invite you to, in the light of that clarification, to repeat your question?
So at trial, one of the questions, the overarching question on the 3rd preliminary issue is the first defendant precluded from relying on the settlement deed by reasons of unconscionability? Mm-hmm. That requires an investigation of the claimant's knowledge of the defendant's knowledge of the underlying claims, the 3 knowledge ingredients we've already discussed. Mm-hmm. At the moment, there's merely an assumption being made about the the defendant's knowledge. My point is that when it comes to assessing the overall question of unconscionability, it isn't a binary question of did they know or didn't they know, but the court may want to know, well, what did they know and how did they know it and to what extent they know it and who within the organisation knew it. It's more nuanced than that, as we've discussed before. So there is overlap, therefore, between the ingredient that you're relying on an assumption for and the overarching unconscionability ingredient, which at trial will need to be investigated.
Yes, because if I have not succeeded in disposing of sharp practice on 3 or 4, then I would agree with my Lord's observation that therefore in finally resolving the issue of sharp practice, one will need to have a clear factual matrix or set of findings as to issue 2 in order to understand how or what is made out there for the purposes of exercising the discretion. It is something of a one-way bet, in as much as I have an opportunity, if I succeed on 3 or 4 or 5, to be able to knock sharp practice out. But if I'm unsuccessful with what is, we say, a relatively confined attack on that, if I'm unsuccessful, then sharp practice remains in
So I
play.
think the answer is, as I thought I understood your answer to my Lord earlier, was the reason there's not a problem of overlap at trial is because the court won't be allowed to go into the question of the overarching question of unconscionability. It's only allowed to answer the specific 4 or 5 ingredients.
Yes, and
which isn't what the order says. But
if for example, at the preliminary issue trial, the court were to say, well, I'm afraid that I've looked at what you say about issue 3 and issue 4, and look at the threshold you've achieved in terms of knowledge, but the view of this court is that you haven't sufficiently succeeded on those issues in order to dispense with sharp practice altogether, possibly by virtue of the fact, for example, that there's unresolved facts on issue 2, and the sharp practice argument has not been determined at that point in time. But when one considers that the preliminary issue trial will resolve the matter, if one has either success under the specific release, in which case sharp practice doesn't feature at all, or it can be resolved if the reliance has to be had to the general release and ingredients 3, 4, or indeed 5 are successful, then that saves a vast amount of court time and cost. So I can understand the concern to say, well, it would have been nice if there's a way of doing this that made sharp practice absolutely finally resolved one way or the other. We've got as close to it as we can to make a preliminary issue trial viable in circumstances where there are a number of pathways through which would resolve the matter finally.
Can I just explore a little bit further whether that premise is necessarily sound? The way you've been putting it at the moment is there are these knowledge ingredients which are necessary steps before you get to apply any overarching unconscionability question. But as you say, knowledge in this context is quite a slippery concept, and it may be that in this area where ultimately the question of whether there's been sharp practice is a question of whether there's been unconscionable behaviour, that different degrees of knowledge might do in relation to different elements when you put them all together. I can quite see that if on sub-issue 3 it's perfectly obvious that the claimant knew that he had these claims, then that might be a knockout, like in Marinello. But if there's a more nuanced aspect, that he might have had a suspicion that this was so, but it wasn't in the forefront of his mind or so on, and yet then if you look at the other elements of what the post office knew and the way the post office behaved and so on, it was regarded overall as sharp practice. That might or might not, but that might be enough to invoke the doctrine. So I'm just wondering whether in what is not a very well developed area of the law, it's right to compartmentalise what are described as knowledge questions, as if they are simply rigid categories, each step of which has to be gone through, rather than part of an overall investigation of what in the end is unconscionable.
Well, I recognise the fact that it is possible that at a preliminary issue trial, having advanced my client's case with respect to preliminary issue 3 and what I say is the knowledge requirement, that the court might say, for exactly the reasons that my Lord Justice Popplewell has just identified, that actually you don't get home on sharp practice issue 3 because the question of knowledge is not sufficiently well defined such that this court would need to take into account other matters. But you, Post Office, have chosen to proceed with sharp practice issue 3 on the basis that you put it, and you have not succeeded.
So who gets home? Are you suggesting the burden of proof is on the Post
No,
Office
no,
on these issues?
On issue 3, the burden of proof is on me to be able to establish that Mr. Castleton was aware. And on issue 4, Mr. Castleton says that will seek to establish that Post Office, if indeed he was unaware, that we were cognizant of that unawareness. But if the levels of knowledge are such that it doesn't allow if the lack of precision on the law as to the levels of knowledge which are, or the knowledge threshold which is to be engaged, get in the way of my succeeding, then that is something that Post Office, a risk that Post Office takes in trying to deal with sharp practice issues 3 and 4 on a preliminary issue trial.
But might issue 2 be relevant to that? It's supposed to take hypothetical with extreme facts. The findings on issues 2 and 4 were, if there were to be findings on issue 2, that the Post Office absolutely knew that he had these claims, and they absolutely knew that he was labouring under the misapprehension that he didn't have these claims. But when it comes to what he actually knew about the availability of these claims, it's a little less clear. He didn't really turn his mind to it. He might have suspected, he might have been aware of some of the facts, but not been aware of that they would give him a claim, however it may be. Now, it may be that if you put all those together, you come to a conclusion of unconscionability in a way you wouldn't if the findings on issues 2 and 4 were so stark.
My Lord, my response to that would be that one does not have a crossover between the knowledge on issue 2 and the knowledge on issue 3, because the knowledge in issue 2 is Post Office's knowledge. The knowledge in issue 3 is Mr. Castleton's knowledge. It is difficult to see that what Post Office knew, what's obviously relevant to issue 2, can have any relevance to what Mr.
No, I'm not on whether there's a crossover between the answer to the questions. I'm on whether actually unconscionability, which is, as I understand it, ultimately the test for sharp practice, involves the same level of knowledge for all the aspects we're looking at: Post Office knowledge of claims, claimants' knowledge of claims, Post Office ignorance of claimants' knowledge of claims, or whether actually there are different degrees of knowledge, belief, suspicion, and so on. And it may be that absolute knowledge on some, but mere suspicion or absence of suspicion on another, when you put it all together, amounts to unconscionability.
Well, my Lord, a level of knowledge, an extent of knowledge, will need to be determined for each of ingredients 2, 3, and 4.
Yes.
And I fully accept the proposition that there is no particular reason why those levels of knowledge should be the same in the case of each ingredient. Maybe they are, maybe they aren't, but I don't see a principled basis for saying that they have to be the same. That is something to develop. But there is no reason why a court at a preliminary issue trial can't determine what the knowledge threshold is for the particular ingredient in question, and then ask itself whether or not that knowledge threshold has been made out on the evidence.
Well, that may not be the right approach. It may not be for any of these sub-issues. It is going to be determinative what test you apply to knowledge. It may be you have to decide what level of knowledge, belief, suspicion, or so on there is in relation to each of those, and then put them together and say, in all the circumstances, is it unconscionable? So just it may or may not be the case, but suppose, as I say, that the issue 4, Post Office, absolutely certain that Mr. Castleton didn't have a clue about him having any of these claims. And when it came to Mr. Castleton's actual knowledge, it was all much more nuanced, and it might be somewhere between suspicion but not facing up to it, whatever it may be. There's a complete, there's quite a range there might be. Now the court might take the view, well actually, having made a determination as to those findings on issues 3 and 4, ultimately, whether we think it's unconscionable is really going to depend on where in the scale of knowledge we're going to put issue 2, about the Post Office's knowledge of the viability of the claims itself. If on the one hand,
Yes.
the Post Office thought, look, he's got a whole lot of absolute slam dunk claims here, we don't even think they're viable, we think they're bound to succeed, that might be rather different in the overall mix of what's unconscionable between, well, we think they may be arguable. And that's all a matter of nuance. That's what I'm putting to you as to whether, in the unconscionability question, it isn't just something you come to at the end of these 4 ingredients, it's part of all of them.
Well, my lord, might I restate the way that I think my lord might be trying to putting it? And again, pictorially, if I may, if one imagines four buckets of water with a different level of water in each bucket, and the question is whether the water in any particular bucket achieves the threshold that is set for that particular bucket. What my lord is suggesting is that when one has performed that exercise, one then has to step back and actually consider the amount of all of the water in all of the buckets as effectively a global system to see whether or not there is room for unconscionability. My response to that, in my respectful submission, is that that is not the way that the doctrine has been framed by Lord Hoffman and by Lord Nichols, at least as it presently stands, which is we have specific ingredients that have to be made out. When you have made out those ingredients, 1, 2, 3, and 4, I stop there for the moment, it may be other factors then come into play. For example, Maranello is an example of a factor that then comes in on top. But if, in my submission, one does not achieve the minimum standard in each and every ingredient, then the state of the law is that there is no room for the equitable doctrine of sharp practice by way of unconscionability.
All right, thank you.
That is my submission.
No, don't.
On that point.
Yes, I don't want you to feel under pressure of time. If we have to go on, we have to go on. You must make your submissions, because I appreciate you've been dealing with matters of substance,
Yes.
and you've got other areas in your quiver.
There are other points to address, but a great deal of what I have to say, in fact, almost everything I have to say, is in our skeleton argument. So what I might do is just bring out just a couple of very succinct points, if I may, and if there's anything that the court wishes to inquire into further, I'm sure I'll be asked. Just in terms of the prejudice point, in terms of making assumptions in one direction or the other, to the extent that hasn't been superseded, I do just draw the court's attention to the fact that reliance was placed or has been placed on the decisions in Satyam and the decision in Royal and Sun Alliance. And the concern in both those cases was that assumptions of fact were inappropriate. What is important to recall in those cases is that there was going to be a final determination of a party's position in circumstances where they had not yet had the opportunity to advance their strongest possible claim. And what is important about the way that Assumption 2 has been framed is that it puts Mr. Castleton's case at the highest conceivable level, because it is an assumption as to the existence of the entire ingredient. Indeed, even if it were to have been the case that there was a defect in Mr. Castleton's pleading on that issue, he would still have the benefit of that assumption and of that ingredient having been conceded for the purposes of the preliminary issue trial. My lord, if I can come back to the other area, which is the scope of this appeal. The order below is doing two very different things. The first thing it is doing is to determine the split trial and the basis of that split trial. We see that in paragraph 2 of the order and in Annex 1. And then completely separately from that, it is then going into the question of pleadings as a consequential direction based upon that. Lord Justice Lewison considered the application for permission to appeal on ground 1 and 2, which go to the split trial issue. And he concluded and found that it was easy to see why the court took the view that the issues raised in Part A of the particulars of claim should be tried in advance of those raised in Parts B and C. The division of the case was well within the bounds of proper case management. Accordingly, my lords, we say that all that is and can properly be an issue in this appeal as advanced and within the confines of the permission granted is the question about the pleadings. That's addressed in grounds 3, 4, 5, 6 and 7 of my learned friend's application for permission. But the permission that's been granted in respect of ground 6 has to be read in the light of the reasoning for the refusal of permission on ground 3, which was that it was a proper exercise of case management powers per Lord Justice Lewison, not to require the defendants to plead to Parts B and C until Part A had been decided. Annex 2 arises because of a matter that might be described as pleading hygiene. It arises because of this conceptual difference between Part A on the one hand, which refers to a body of text on the page, and the Part A claims on the other, which are the matters for determination at the preliminary issue trial. Now, that conceptual delineation was brought to the attention of Mr. Castleton's legal team in the skeleton argument below. And importantly, it was brought to the court's attention and to Mr. Castleton's attention during the course of oral submissions, because this court will recall that Mr. Justice Trower and Master K stepped out to consider their decision and came back in the middle of the afternoon and indicated that they were minded to order the split trial on the basis contended for, and then moved on to the consequential matter of dealing with what pleadings should follow. Now, there was before the court and in the possession of Mr. Castleton's lawyers the draft order, which included Annex 2 and which included all of the words in Annex 2 save 6. And what happened was that during the course of the discussions on pleadings, no objection was taken to the Annex 2 concept by Mr. Castleton, the delineation between Part A and carving out the gap between Part A and the Part A claims. But when the draft order was finalised after the hearing and sent to Mr. Castleton's lawyers, at that stage, Post Office identified that 6 words had been left out of Annex 2 that fell into the gap between Part A and the Part A claims. And so efforts were made to then add those additional 6 words. And this exchange, which I'm going to show you, is extremely important because what it demonstrates is that Mr. Castleton, by his lawyers, agreed to the Annex 2 concept, and he agreed to all of the words of Annex 2, bar 6. Might I invite the court to turn up the supplementary bundle, please?
I think Mr. Marshall agreed.
Yes, I think Mr. Marshall agreed with that, that he'd agreed with this wording.
And my lord, in those circumstances, therefore, what is effectively being sought to be appealed is something that has been consented to by Mr. Castleton. And we say that gives rise to some quite serious concerns, because once parties are allowed to start to appeal that which they've agreed to, it raises a question mark as to the finality of litigation and certainty of the outcome if a party faces the risk that a U-turn is done on something that has been agreed to. It is not as if there has been a material change of circumstance. It is not as if some new fact came to light. The existence of Annex 2 was known, the concept of Annex 2 was known before the hearing, at the hearing, and in the week that came after the hearing. And so, my lords, in those circumstances, we say that it is simply not properly open to Mr. Castleton to complain about any aspects of Annex 2 as a matter of concept, or any of the wording, apart from potentially the few words that were added in. the resolution of position on that was addressed by our sending some short written submissions to Mr. Justice Trout and to Master Kay, indicating that those words, we said properly, should be excluded. No principled argument was advanced against that by Mr. Castleton, save for the fact that he says, well, it wasn't in your draft order before the court, and therefore you can't put it in now.
Are the 6 words relevant to the argument that's been going on today? I mean, the 3 words are wrongfully and unlawfully.
Not wrongfully and unlawfully, but the point I'm seeking to make is that if this appeal is in fact based upon, or this appeal should not be allowed to proceed if in fact it's sitting on the basis of something which has been consented to. And I'm, with due respect to Lord Justice Lewison, I'm not sure that it was entirely clear to him, I'm not sure how it would have been clear to him when he read ground 6, that in fact this had been the subject of agreement. The difficulty that we have is that the reasoning that the learned Lord Justice gives with respect to ground 6 appears to address Annex 1 and not Annex 2. I have a hypothesis as to how this might have happened, and I don't know whether the court has any interest.
Well, I'm looking at page 41, which is your skeleton argument, where you're, as I understand it, covering these sorts of arguments. Paragraph 33 and sub-paragraphs there too. Is that?
Sorry, my lord, paragraph 30...
30.3. 30.3 and its own sub-paragraphs.
Yes, and indeed in particular at 30.3.3, that the last sentence of the quotation, it is no answer to say for the purposes of the preliminary issues these are to be assumed. And I think what is being said there is that that is a theorising by Mr. Marshall as to what we may or may not say in response to arguments about whether or not we should plead. There is a possibility that that was read to mean that in fact there have been such assumptions for the purposes of the preliminary issues, but of course the assumptions that are made are set out in footnote 1 to Annex 1.
But the meat of the permission seems to be the paragraph which you very correctly quote at 30.3 itself at the top of that page. If we're trying to work out what permission was in substance granted for, it would seem to be that it was in substance granted for that argument. You say that the door is ajar for that argument.
The awkwardness there that arises is how much room there is to manoeuvre when one looks at the reasons given by Lord Justice Lewison for refusing to permission on grounds 1, 2 and 3.
Yes, well, I can see that that's a problem for us, but we're concerned really with the suggestion that in a sense, I hope I don't misrepresent your argument, that you're saying that because there was agreement to it and because you didn't get permission for anything other than 6, we shouldn't be entertaining the argument for which permission was granted, according to the way in which the permission on ground 6 was phrased.
That is the point I make, my lords, but
yes,
of course
well, I mean,
it's a matter for this court. The difficulty that one has is that one, obviously, any litigant comes to an appeal on the basis of the ground of appeal that has been...
You'd be surprised how often this arises. Even this week. But I mean, I think we very well understand the difficulty for a respondent in this sense, but I think we would need to hear you, if you are saying, as I understand you to be saying, that we shouldn't entertain the argument which Lord Justice Lewison seems to have identified, and you've quoted here. We'll need some help with that.
I'm not proposing to take that point any further than it is
well, that's helpful.
In the skeleton argument. My lords, might I just turn my back for a minute?
Yes, certainly.
My lords, unless I can assist further.
You can.
Just one point. How much debate was there below about Roman numeral 2 in footnote 1 on page 116? You've told us that Annex 2 was agreed. Can you make the same point about that, or is that...
So this is page 116.
Yeah, so this is the extent of the assumption. The assumption on the second issue in unconscionability. To what extent was that debated?
There was no debate on that, to the best of my recollection. Mr. Castleton's position throughout that hearing was, for the most part, that there should simply be no split trial at all. When questions from the bench suggested perhaps that the court was leaning in favour of a split trial, Mr. Castleton's argument moved to say that there should be, if I recall, a split trial on claim 1, construction only, which I dubbed a preliminary issue. I was invited as to what the Post Office's position was on that, and our response to the court was that we didn't think that was the right way of progressing, because that would resolve nothing determinatively.
So this point wasn't that, so you can't go so far as to say it was agreed that that should be an assumed issue.
It wasn't. I can't say that there was anything that amounted to clear and obvious consent, but no objection was taken to my recollection is that no objection was taken to those specific words
when the order was being drawn up,
or indeed during the course of the argument, because of course this draft order was before the court for the purposes of the argument. We have the transcript, and I can look and I can check, but my recollection is that Mr. Marshall's submissions were tailored to the concept of a split trial in its entirety.
Right, and the footnote was there, and anyhow the footnote had an ancestry which went back into written submissions previously.
The footnote was in the Castleton argument, which was produced and served about 4 days before the hearing. And Mr. Justice Trower made the observation, as my learned friend identified, that he hadn't spotted the significance of it the first time he read the Castleton, but he did the second. And Mr. Justice Trower then made the observation, but no doubt Post Office would say that the assumptions that had been made there would be as night follows day. He considered that it seemed, I think, fairly obvious that those assumptions would be made in order for a preliminary issue trial to be able to work, because one has to remove 2006 and 2007.
Good. Thank you very much indeed.
My lord.
Yes. Now, Mr. Midwinter, you don't need to watch the clock.
Right.
We need to hear your submissions as you wish to make them.
Well, my lord, the position is, of course, that my client's interest in this particular point is limited. Unconscionability and sharp practice are not matters alleged as against us. Our concern is that the split trial should take place. The basic fact is that this is a case in which there is a dispute about whether the claims have been settled, and there are the underlying claims. The reasons that the judges gave below, in which Lord Justice Lewison saw merit in, there is obvious sense in having the question of whether the claims have been settled tried separately and first. Insofar as we are debating today a question of whether a particular assumption is made or is not made at that trial, whether something is determined on the facts or is done by way of assumption, in a sense, my client is indifferent. What matters is that that trial is effective and decides the Part A claims. And so the only points I was going to make are three. The first was to reiterate what Mr. Bailey has already drawn your lordship's attention to, the difference between ground 6, for which permission was given, and the point that we are now debating. I won't take that further. The second is to suggest that to some extent more is being made of this footnote assumption than it really deserves. As we see it, what the effect of the assumption is that the Post Office is accepting that for the purposes of the Part A trial, it is not taking a point on what's been called Lim 2, its knowledge. It's in effect as though it had admitted that it knew that Mr. Castleton had viable claims. We're in the same position as if they were an admission.
The legal element.
The legal element of that,
Yes.
of unconscionability, absolutely. So that's taken to be admitted. So whatever the test may be, and as my Lord Justice Popplewell was debating
with both my learned friends, there may be scope for argument about what the test for knowledge is at that stage of the unconscionability assessment. We are going to proceed on the basis that the Post Office accepts that it had the relevant knowledge. And so where we are, as I say, is in effect as though there were an admission for the purposes of Part A that the Post Office knew that Mr. Castleton had claims. That being so, we then go on to determine whether Mr. Castleton knew he had claims and whether the Post Office knew or did not know that he knew he had claims, and the overall assessment of unconscionability. But of course, one can't force the Post Office to contest the issue of knowledge. The position is that it is admitting it for the purposes of this trial. And a lot of the questions that came from the bench with respect were dealing with the practicalities, what the effect of that is on the way that the Part A trial will be conducted. How will witnesses give evidence? What will disclosure be? And on that, my submission would be this. That was a point which the judges below had in mind. We are going to come to a CMC in these proceedings on, I think it's the 1st of July.
It's a long one. How long is that?
I think it's not been finally fixed yet. Is it 1 day hearing?
The idea is that it would be about 2 days, but unfortunately, because of this appeal, that hearing has been lost as a CMC, and will be other matters will be dealt with then in the CMC.
Right, but the assumption was that there'd be a CMC of about 2 days.
Yes, with further reading.
Sometime, yes.
The court, in paragraph 41 of its judgment, acknowledged that disclosure and oral evidence is going to be required for determination of the Part A claims, but made the point that it's going to be less than and very different from the disclosure and evidence that would be required for determining the underlying substantive claims. Something that we are going to have to debate before Mr. Justice Trower and Master K is what disclosure, what witness evidence is going to be appropriate for the Part A claims. And I can well see that in light of what has fallen from the bench, Mr. Marshall may at that hearing say that the disclosure needs to be more extensive than perhaps the Post Office would suggest it would be, that the witness evidence should be more extensive than the Post Office might have suggested it would be. But those are issues of case management to be debated before the docketed judges at a CMC whenever it takes place. They are not, in my submission, reasons for, certainly not reasons for questioning the wisdom of having the Part A trial as a split trial, and it doesn't mean that we need to interfere with the assumption that has been made. Because as I say, all that that assumption does is mean that the Post Office is not contesting limb 2 of the unconscionability test for the purposes of the Part A trial. What effect that has on the evidence that we need at that trial is a matter yet to be debated.
Well, it's of course you're right to say that people can't be forced to contest things, but can't it be put another way? It would be that they don't have to answer for things.
My Lord, I'd submit not.
On the facts.
What
in a sense, you're presenting it as if it was a pure benefit to the opposing party. But might it not also be characterised as meaning that it's a shield, keeping the opposing party out of any of that materials?
Well, my Lord, my submission would be no, because as I think Mr. Bailey said in terms towards the end of his submissions, the effect of the assumption is that on that point, Mr. Castleton's case is being put at its highest. His allegations are being
legally at its highest.
But for the time being, as an assumption, when you say that it is in effect an admission for a trial of the Part A issues,
yes,
you are assuming that, which Mr. Bailey contests, that the preliminary hearing will necessarily determine all the Part A issues. And he says it won't. If it comes to the point where that assumption is critical, then he won't be able to decide it, and the court will have to come back to it. So it's not an admission; it is an assumption.
With respect, well, I think you are giving admission a more technical meaning than I intended. I'm not suggesting that it's an admission in the sense that the Post Office can't come back to it if Mr. Bailey insists that that right is being maintained. What I'm saying is that for the purposes of the trial that's going to happen, that is going to take place on the basis that the Post Office accepts, for the purposes of that trial, that it had the relevant knowledge, whatever it may be, whatever the test for knowledge may be, whatever it is that Mr. Castleton alleges the Post Office knew, that is accepted for the purposes of the Part A trial. So it can't be put any higher. It can't be any better for Mr. Castleton than that the case that he has alleged is being accepted for that purpose.
It's not being accepted, it's being assumed for the purposes of deciding the other issues. In other words, it's being parked for the purposes of deciding all other issues in the case, but it's only being parked.
Not in any relevant sense. It is Mr. Castleton's case on the Part A issues is going to be decided on the basis of his pleaded case. The Post Office is not challenging his pleaded case as to its knowledge. So
Well,
the effect of
no,
that.
Not at this trial.
No,
But
not
it's,
at this
it's
trial.
holding out for a second trial if it doesn't succeed at the first trial. That's what Mr. Bailey said.
Indeed, my lord. I mean, that is a separate issue. The point that I'm on currently is that there's no difficulty at the trial that we're going to have caused by the fact that the Post Office is, for the purposes of that trial, accepting Mr. Castleton's case at its highest.
Was it clear to the judge that this was the effect of the assumption? I think there wasn't much debate before the judge, so the judge is. I'm not sure it would have been.
Well, what's set out in the judgment, one can see, is actually at paragraph 40, the page just before we were on, page 126. I see at 40 sub 3, they say, in light of Post Office's clear statement as to the basis on which issue 3 will be determined, it involves a discrete and confined inquiry into the claimant's knowledge, if any, of the Part B claims and the Part C claims as at the date of the settlement deed, and the extent to which the POL knew of his state of mind, will also require an examination of the effect of the general release on the doctrine of unconscionability. And then we get to paragraph 41 where it said we'll need some disclosure and oral evidence for that. It is right that Mr. Bailey's submission today that the Post Office might be warehousing a fallback case. So if it loses on Part A, it could come back and say it didn't have the relevant knowledge, is not how we had understood the preliminary issue trial to be proceeding. Our understanding is that it is to be a trial of the Part A claims, full stop, as set out in our skeleton argument. But whether I'm right about that or not doesn't affect the point that I'm on at the moment. I understand my Lord Justice Jackson's point that Mr. Castleton might like to cross-examine Post Office witnesses and and inquire as to the state of their knowledge, and that by assuming that they have the knowledge, he might be deprived of that opportunity. But my submission to your lordships is that that's not a legitimate juridical advantage. The case is going to be determined on the basis that his case is right, and you can't get better than that. So if all that you want to do is give the witnesses a beating for forensic purposes, that is not a legitimate complaint. That's not a legitimate disadvantage. There is no juridical disadvantage to Mr. Castleton. There cannot be in proceeding on the basis that his case on this is correct.
He's pleaded his case as it stands, but he's not had disclosure at this point, or at least it's clearly a great deal out in the public domain, but there's been no formal exercise of disclosure. So we're all very well aware of situations in which one case gets better after disclosure and also when it gets worse. Isn't that the practicality of it?
No, my lord, but it can't get better than being accepted. That's the point that I'm making. So, as I say, Mr. Castleton's case on knowledge, however highly it is put, the Post Office are not contesting they had the relevant knowledge. What they are saying is, even if we had that relevant knowledge, there's no unconscionability here for reasons 3, 4, and 5. Now, your lordships have put to Mr. Bailey that there's an overlap between issues 2 and 4, and so questions may be asked on issue 4 which have some overlap with issue 2. And the submission that I'm making is those questions of practical overlap are in fact questions about what the scope of disclosure should be, what the scope of witness evidence should be, and those are matters that are yet to be decided at first instance. They are not matters that your lordship need to concern yourselves with. If we are taking it that this point is properly an issue on the appeal, whether that assumption should be made, my submission is that the only effect of that assumption is that Mr. Castleton's case is to be taken to be accepted for the purposes of the Part A trial on the Post Office's knowledge. That cannot be something that prejudices Mr. Castleton. It cannot be something that causes any particular difficulty because the effect is the same as if the Post Office had admitted it for this purpose. And therefore it's not something that your lordships need to be concerned about. The practical effects, as I say, are yet to be worked out at first instance. And my lord, subject to my overarching position on behalf of my client, that our interest here is in ensuring that there is an effective Part A trial, because our position is that these claims have been settled and released, and that it is in no one's interest to go to the enormous expense of a trial of the substantive claims if that is right, and that therefore a split trial is the right way to go. These are points of detail about how that trial is conducted, which in my submission don't warrant interference from this court, which we can debate, and no doubt will debate further, with the docketed judges.
Right, now I had you down for 3 points.
Yes, I think I combined the two. One was to acknowledge that our indifference and the
Yes,
importance
okay,
to us of
so
getting
that
into the
was,
trial, and the third was the point that I've been talking about too long.
Well, thank you very much indeed.
Thank you.
Now, just allow us a moment, if you would. We're obviously not going to go to press Mr. Marshall for his reply now, and also we see some advantage in, unfortunately, having to go into the afternoon, but only for a short period. So that time is best used. Could we invite you all for a moment, and purely for hypothetical purposes, so that we've heard argument on everything that we need, and don't have to come back to you at a later stage. In the hypothetical world in which, to a greater or lesser extent, the appeal were allowed, could we please have submissions from each of you, in addition to the reply, as to what the consequences ought to be for the disposal of the appeal? I appreciate that that leaves matters in a very broad framework, but I think we'd like to know what the parameters are of your submissions on that matter. So could you please spend, I hope, a short period of your break thinking about that, and let us know the answer to that as well. We'll hear from Mr. Marshall first in reply, and then ask you each for your views on that further point. We'll now adjourn until 2:05.
Rise in favour.